Good morning and welcome everyone. I'm so pleased to be here at this cutting edge seminar today. You're all here because you're getting ready to make a transition, a very big one. My husband and I made this 20 years ago actually. He retired. And it was difficult. Transitions are hard, they're very stressful, and those of us with children with disabilities, it is even harder for us because we have all these additional services to make sure are in place as we make that transition. So the good news is by being prepared, by getting some information, by having a plan, by being here today, great step, you're going to be able to make that transition go much more smoothly and it'll be much less difficult for your family. My part in the piece today is to look at special education law and how those services might be changed if you have a child receiving those services, and I've also been asked to address guardianship and conservatorships. There's a lot of misinformation about them. I get calls all the time from people. Got a call just yesterday from a Marine that has a 14-year-old son that says, I have to have a conservatorship. I'm getting out. I need you to do it for me now. Well, you'll have the answer on why he doesn't need it yet. I want to make sure by the end of this presentation you know whether you should even consider a conservatorship for your child. And I want to make sure that all of you have a will, and in that will you have a guardian appointed. Okay? All right. And I will stay afterwards. Disclaimer, this information is provided for educational purposes and does not constitute legal advice. I am a California state licensed attorney here. Okay, so special education services. What are we going to look at today? We're going to look at how do the services change when you leave the military. You're going to be surprised special education services are not going to change unless you change school districts or you move out of the state. And we'll talk about what the new state and school district have to do. What can you do to ensure continuity of care for your EFM? We're going to look at support services. The biggest thing that you're losing actually are your EFMP caseworkers, the program managers, and my free services at this point. So if you can use those as much as you can before you get out, I am a free attorney for all the Marines here. You can call my office. If you have any questions, please don't hesitate to contact me, because once you leave, you can't use my services anymore. Okay, you can be directed, and I'll talk about pro bono services that you may be able to access once you get out of the service. We're also going to look at older kids. I'm assuming some of you may have some of those. Older kids, we're looking at the 16 plus because special services come into play when your child is hitting that period. So we're going to look at those. And then what civilian resources do I think are the really good ones for you? Okay, so special education services, we have 3 tiers of regulations. The federal law, which is the IDEA, IDEA stands for the Individuals with Disability Education Improvement Act of 2004. You may be hearing more and more about this. They're thinking about what they're going to do with this. It was supposed to be reauthorized every 3 years. Haven't done it for a while, have they? 2004, last time they looked at it. Major changes coming down the educational field, I think, very shortly. The other law that your children may have now is the Section 504, the Rehabilitation Act of 1973. If your child has a 504 plan, that's the law that rules there. These are federal laws, not going to change. You guys get out of the military, they're still there. Here's what we'll have the difference. As long as you stay in the great state of California, California state law is what's going to be important for your IEP and your child's services. And then your local school district each has separate policies also. And I'll talk about those a little bit more in detail. I want to go over and make sure you all are very familiar with IDEA and your major rights. Some of you, and I know some of you have been my clients out there, know the law very well. You know where to get it. You know every time they hand you the procedural safeguards that I want you to take it, whether you've read it or not. You know, just last week, please take those and read and make sure that you know them. Very important. So most important is you have a right to participate in every decision regarding your child's education. That means that they can't hold those meetings without you. They can't predetermine services for your child. The school districts can't. You need to be aware of those rights. When you have a dispute with the school, or you don't agree with the services that they're offering when they make that offer to you, there are certain very formal steps that you can take to make sure that those are addressed properly. Second, your child has the right to a free and appropriate public school education. FAPE, okay? FAPE isn't best, it's appropriate. And if you've gone to my other presentations, you know this famous law case, the Rowley decision back in 1982, I see people shaking their heads, that set forth this standard that our children with disabilities are not entitled to the best education, but to an appropriate education. Best in my field is a four-letter word. Don't use it. Learn to get it out of your vocabulary and learn to use appropriate all the time, okay, when you're at those meetings. Third, the school's offer of FAPE, free, appropriate public education, is written in the IEP, the Individualized Educational Program, that's developed, reviewed, and revised in accordance with federal and state laws. The federal and state laws are very specific. There are so many things that have to be in that document. That boxes have to be checked, or that IEP is not going to be valid. There'll be compliance issues, procedural violations that the school will be violating if it's not done all according to the law. So this is the federal law. It's not going to change, okay? But I want to make sure some of your faces are not familiar, so if you have an IEP, this is a starting point. This is what you need to know. Okay, so here's the easy one. You don't move. You get out of the service. You're in the same state. You're in the same school district. You have the same IEP. Nothing changes, okay? Scenario 2. You change school districts. Some of you are in not DOD schools, but school on the base. You're living in base housing. You're going to be moving out of that possibly. So you may be changing school districts. This is where the law comes into play. So, again, you're transferring in the same state to a different school district in the same academic year. We're not looking at the summertime. That's a little different, really convoluted, and I don't want to get into that today, but you can talk to me if you're moving during the summer. But if you're moving in the same academic school year, the federal law was very clear that when you make that changeover, the new school district needs to pick up those services immediately and not let our children with disabilities services lapse. So you're going to move in, and they're going to give you a comparable IEP. It's going to have comparable services to the prior IEP. All right? In California and some other states, but in California, if you move within to a new district, they have 30 days to look at that, put that in place, and then that new district must either adopt that IEP. Usually each district has its own form, so even if it adopts it, it's going to put it on its own form and do it, exactly the same. Or they can implement a new one. They can look at that other school district and say, we don't agree with those services, or we do this differently. We have learning centers rather than special day classes. We do something differently. But they only have 30 days in California. Now, comparable services is something else. It does not mean the exact services. I have clients that are coming from DOD schools in Virginia usually, and their IEPs are all written in minutes. They have 1,504 minutes of special education in a special ed class. A lot of the districts out here don't do it by minutes, they do it by hours. So we're going from 1,504 minutes. What's comparable? Well, 3 hours. So you're going to see a slight shift. Yeah, you're losing some minutes, but it doesn't have to be exact. So don't hold that new school district to the exact services that you're receiving. Questions? Now the harder one. I assume somebody here in here is going to be moving home. Texas, Kansas, Wisconsin. So I see smiles. Yeah, somebody's moving, right? Going home. Good for you. This is where this part comes into play. So now you're going from the great state of California to a different state. First thing I would do is I would check the state law, and I'll tell you how to do that. You need to make sure that you know what the law is in that new state, because you may have a time period. There may be a 45-day grace period there where they can only hold that old IEP for 45 days. I don't know. In California, there is no set time period for this. So you're coming into California from Texas or Virginia, okay, with an IEP. The new state has the right to really redo everything. But in the interim, again, they must give you an IEP with comparable services. Does that mean exact? No. Good. Good. I'd like to see the heads. Yes. So they will write a comparable IEP, and then the new state has the right to look at eligibility all over again. So if you have a child with high-functioning Asperger's, or a child with ADD or some other health impairment and was on the borderline with real minimal services in one state, you're coming to a new one, don't be surprised, especially in California, that they will redo that evaluation all over again to see if you're even eligible. Once they do that assessment and make that decision and give your child an eligibility category, then they're going to see whether your child actually needs special education services. Two-step process, okay? So that's coming into the state. Any questions there? Okay, so here's my tips. And I do get clients coming in all the time, obviously, mainly from Quantico. Start early. You guys are doing a great job being here. I'm hoping you guys have a couple months' time. So that's the most important thing, is to get this going now. 2, get a copy of your school record. This great state of California, again, has a wonderful law where if you put a written request for your child's record into the school, hand it to your principal at the front office, 5 business days later, they must give you a complete copy of your child's school record. And the caseworkers at all the installations have form letters that you can request, and you can just fill in the blanks and hand it over. 5 business days. Really important you're doing this if you're getting out of the school districts. You want to look at that record. You want to make sure that it's complete. If you think that there are things not in your child's record, you can petition to put things in, and it's fairly easy. If you think that there are things in there that shouldn't be, you can also request that those be pulled out. Sometimes there's really private information, maybe a medical form or something that you didn't know got set in that file. You can request to have that pulled. Okay? So this is the FERPA law, the Family Educational Rights and Privacy Act, that gives you this right, and 5 business days. In Virginia, it's 45 days. So don't be surprised if you go to Virginia and you put that request in there. They have 45 days to do that. They also can charge you for that record. They usually don't unless you get, you're sideways with the school district, okay? But usually they'll give it to you. And if they won't copy it for you, take your own personal scanner and go into the office and scan it all in, okay? Very important to do that and look at it. I also offer, probably starting mid-June, if you're still here, I am offering a consultation for families that are leaving. If you want to get that record together, get me a complete copy. I can usually turn it around once school is out. In a couple days, we can sit down and you can either come up to Camp Pendleton and we can walk through that file to make sure everything looks good. I can review that IEP for you to make sure that your goals are looking really like they should be, golden IEP, before you make that change or before you get out of the military. Why, you've got free services here. I'm going to be at a first-come, first-served kind of basis. I don't expect a lot of you will want to do that, but please, if you'd like me to look at your child's IEP or give you, do a once-over of your child's file before you leave, just let me know. I've got cards over there. Email's the best for me. You guys know what the phone system are like here. So email me, put a request in, say you attended this seminar, you're getting out at such and such a date. I can send you that form letter and we can get moving on it. okay? 3, if you know you're going to be leaving the school district, start researching that new school, okay? Go in there. If you have anybody else that's going there, try to, get the other families, any other family members that you might know, get information about that new school. Visit the school, observe the classroom. Children, don't let the school say, I just had an IEP where a special ed director told me that my client couldn't go in and observe the new school because these children had a right to privacy. There is no right to privacy in a school. Just like in a school bus, they can video your kids. You don't have a right to privacy there. So if you're asking for an observation, they can put restrictions, a half hour. They can have somebody walk through with you. That's perfectly fine. But you do have a right to go and look at that new school. 5. Here's where my clients, I have trouble. I get a client coming in from Virginia to San Diego Unified, and they start talking and things start going not right. Well, they didn't keep records of it. They didn't email. If you have any clue that there may be an issue or problems, start documenting from the very get-go. Get a little notebook that you can't pull out the pages. Put the date, the time, who you talked to, and what was said. Or email, and keep your emails. I just won 80 hours of compensatory education for a student here at San Diego Unified because we kept emails. The things that the teachers said to my client were just not appropriate. 80 hours free services because we had emails to back up all our claims. Wasn't hearsay, okay? And last, here's a really good tip. I wish it was mine, but somebody gave it to me. Ask if you're moving again, any of the current teachers that you have or any current providers, if it's speech and language on the outside, get them to put something in writing for you that to take to the new school, to the new district. It really helps. They'll look at that and they'll really, it'll be very helpful for them to see that in written form, much easier sometimes than getting on the phone and calling across the nation with the time differences. So get those, ask them if they'll do that. What really works for your child? You have a autistic child that has really high needs, and what works? Sitting on the ball, is that what works all the time? If we just have that one thing in place when he moves to the new school, that may be a real helpful thing. Or whatever else they need. Get those teachers, ask if they'll help you and write those letters for you. Okay? Okay, older kids. We don't usually talk about older kids because most of my clients have younger kids, although they are getting older at this point. And those kids are the ones that are in juvie hall. Hopefully you're not there. But let's look at your child when they turn 16. They have the right to have transitional services, a transition plan. So the first IEP to be in effect when the child is 16 must address transition services. Just like the transition that you're all going through, the transition that your child will go through from high school to either college, vocational education, employment, or independent living is going to be really important, and the school can help you with all those things. So if you start at 16, you can get these services put into place on your IEP. There's some really good books out there about transition services for children, and I know that they have them here and they have them up at Camp Pendleton also. So these are the services that you want to have actually written in the IEP. I have 2 special needs adult children. It's like an oxymoron, but do your kids ever not be your child, right? Adult children. I have 2 adult children. One of them has very high needs because of emotional, mental illness. When she graduated from high school with a high school diploma, very low IQ, she still got her diploma. She went out and was not able to even hold a full-time position, but she can get around town. She can do things. I put in her IEP, she was going to learn how to read a bus schedule. You know how hard that is? That's hard for me, much less my daughter who has, it's very difficult. They really work with her because she would get lost. She wouldn't get off the bus at the right spot. She took the Sprinter and took the coaster. I'm up in Oceanside. And she'd lose her badge. then they'd pull her aside and go, you're writing this illegally. So she had to be able to take care of all those issues on her own. That's the goal. Self-sufficiency to the greatest extent possible. My son, on the other hand, went to, on the other end of the spectrum, very bright, but learning disabilities, went to community college. But he, at 18, had to go into the student with disability office all on his own. Mom's not going to hold his hand anymore. He's going to go on his own. So he's got to be able to do that. These are the services that are called the transitional services. Independent living, all of your basic needs can be written in that IEP for these kids, starting that IEP when they first turn 16. Very important. I addressed the self-advocacy a little bit. That's my daughter getting on that bus when she got lost, being able to know who to go to. When she's sitting on the train and somebody sits next to her and makes an inappropriate comment, I can't help her when she calls me on the phone all the time. I may not pick up the phone to be able to go, you need to get up out of the seat, you need to go find an older woman, you need to go tell her what happened, to walk her. I can't do that. I'm not there all the time. I'm not going to pick up my phone 24/7 necessarily. She needs to know how to do that on her own. We had to walk through that scenario a lot, okay? She had to be an advocate for herself. So your child with these transition services really need to know themselves, know what they need, okay? And how to get them, how to address them in the outside world wherever they are. Another thing that's very important that's going to save you money is to make sure you get a current evaluation before your child leaves high school. You may have to push on this, you may have to be a little sneaky, but if your kid is going like mine did to community college and he needed to keep the accommodations, the community college disability center asked for certain documents from his doctors and the last IEP that he had or the last 504, and if you have those assessments done by the school in the last 2 years, those are usually going to be sufficient. You want to check if they're going to a college what that student with disability center is going to require. Will they take an evaluation that's over 5 years old? What's their line? Does it have to be within the last 2 years? Then you push the school to get that done before they exit. Also for regional center, sometimes they want the school to complete those so the closer to where they're getting out of there, the better off you are. And you won't have to pay for one on your own. Okay? Current evaluation. Last thing for these kids, you want to make sure you know whether your child is getting a diploma, is on the diploma track with all the rest of the kids, or whether they're going for a certificate of completion. This is an IEP team decision. That's up, you're part of that team. Don't let the school force you into it. Don't sign the IEP if you disagree. This, we can work this out usually. There's a big difference for a child that may want to go to community college eventually if you don't have that high school diploma. So you need to look at this very carefully and consider it. So the regular high school diploma, they have to meet certain state requirements here in California, the A to G requirements. They also have to pass the CASI, the California High School Exit Exam. Now, right now, they just extended a waiver for special education students again until January of 2013. There's a law pending to extend it to July 2015 to waive the CASI requirement. So your child could be diploma bound, have special education, but they can't pass the CASI, and they may waive that right for your child and they'll still get a diploma. Okay? There's a major problem with this. Once you get that diploma, what happens? You graduate, you're out. If you have a child that still has needs in your IEP and you want them to continue until they're 21, you don't want it. You don't want this to be waived so the school can go, services are ended, they're 18. So you need to be very careful again if you want to go along with the waiver. That will stop. Once your child gets that diploma, they're out. No more services. Okay? The certificate, if you're certificate bound, they usually have to complete an alternate course of study, which the IEP team puts together. They're going to look at meet their IEP goals, objectives, and meet all their transition services that are put in the IEP that we talked about. And remember that the students on the certificate track do get to walk up and graduate and partake in all of those ceremonies. So they're not going to be deprived of that. Okay, talked about graduation. Where's the clock? Okay, I'm good. And then the magic age of 18. They become an adult. I remember when my daughter turned 18 and I called the psychiatrist to make an appointment and they went, they always ask you for the birth date. They must have a little thing there that automatically tricks them to go, you can't make that appointment anymore because she's an adult. I was like, are you joking? Okay. So what do I need to do? Well, my daughter had enough wherewithal to sign a release so that I was able to do that. If your child is nonverbal, depending on who your providers are, they may go, you can't make that appointment until you get a conservatorship. Okay? Magic age of 18. Also, in the IEP meeting, when your child is about to turn 18, the school will tell your child that they are going to get these rights when they turn 18. They have the rights at that point to sign on the IEP unless you work out something with the school and your child. Usually you don't need a conservatorship to do this. Usually the schools just even slough over this, to be honest. They'll tell the child about their rights, but they go, okay, you parents are still here, the parents are still taking care of this, and the parents are going to sign, and the child's signing too. So this is not on an IEP usually a major issue. But you want to check again with your school district to make sure that it's not. 18, they're adults. Okay, support services. So here's where you lose out. You lose your wonderful EFMP caseworkers and all the programs that they provide. So where do I recommend you go? Start at the top, go to the department. Internet is just fabulous. I use it all the time. Everybody does, right? Start off with the Department of Education. There's always a drop down for special education. You can get the IDEA laws there. You get all sorts of information from that website. Then go to the state, California Department of Education. Again, a fabulous website. Drop down to special education. You can have everything. You can go and get the CASI requirements there online for California. You can see what the retention policies are. Everything is there online. Okay? State disability groups, there's a lot of them. They're the ones that may offer pro bono services if you need them in your state. So here in California, there's a state disability agencies that may take pro bono cases, depending on, a lot of it's income-based, but you can always Google those. Wright's Law is absolutely the best. Pete Wright, who wrote a bunch of special education law books from emotion to advocacy. His website has a drop-down on the left side by topic. So you can look at FAPE, you can look at retention, you can look at adaptive PE, just full of little drop-down on the side. And it also has a military DOD drop-down right now. He offers cut rates on books for the military, so if you're getting out and you want to get his books, do that before you leave. COPA, the Council of Parent Attorneys and Advocates. This is another group. I'm a member of this. This is a national organization for attorneys that represent parents and also for parents. There's a great listserv. Parents ask questions online. There's always attorneys that are watching the listserv. The parents will also respond to your questions, but there'll also be attorneys that will answer questions. I think it's maybe $50, $75 a year. It's fairly cheap for parents to join this. And again, you have additional resources. So just go to COPAA. NICHE is another one of the major national disability centers. Great resources there. Again, there's a lot of training online there that you can do online with their group. And then Probably the most important thing is to get into new support groups. So you're going to look at your child's disability and get into one of these groups. CHAD, the Children and Adults with ADD, they have state and local groups everywhere. They're fabulous for the kids with ADD or spouses, my husband. Autism Speaks is a great one. NAMI is the National Alliance of Mental Illness. I moved here from Virginia, I joined them immediately. I wouldn't be here today without them. They were my support. They got me through everything I went through with my daughter. Fabulous organization, and they really look at legislation, making sure that as we're getting the cuts in California, they're really going to help advocate to keep some of the funding for some of our mentally ill citizens here. And last one, the National Center for Learning Disabilities, really excellent, again, when you have a child with learning disabilities. And a lot of you have children have more than one eligibility category. You may have autistic and learning disability, or blind and deaf, or learning disability. This is a fabulous site. Okay, so here are really good sources to go to. Okay, so that's the part on education. There's really not a lot that's going to change. As you can see, it's the support and taking that IEP to a new district or to a new state. All right? So let's move to conservatorships. Conservatorship, what is it, okay? It's when an individual or an agency, we call that the conservator, is appointed by the court, a judge, to be responsible for the person, the conservatee, okay? What it's doing is it takes fundamental rights away from the conservatee, from your child, well, it's not your adult child, okay? Because it only applies to children over 18. Now again, very careful here. In California, we call it a conservatorship. We make a distinction between a conservatorship and a guardianship. In other states, they're both called guardianships, okay? So just make sure you're getting the right one if you're moving to a different state. But we're looking at over 18 for a conservatorship. So remember at the very beginning, I told you the dad called me. He's getting out, and he has a child that's 14. It's too early for him. You don't need to start this process. It usually takes, I've just recently done 2 of them, one up in Riverside and one down in San Diego, and they both took 3 months and about 5 months. It doesn't take that long usually to complete these, okay? So you want to make sure you get started before the 18th birthday, because it's a lot of paperwork. You got to get a court date, but you're not going to worry about this until they get close to 18, okay? And this is going to last until it's terminated by the court or the death of the conservatee. So types. You have 3 types. The latter one I just put up here so you know. Again, this is California law. The bottom one is the Lanterman-Petra Short. It's an LPS. It really deals with adults with severe mental disorders. Okay, so we're not going to go into that one, but I want you to know that that was there. Again, best place to go for this, if you're up in Riverside County, you're going to go to the Riverside County Superior Court. Down in San Diego County Superior Court website. Look at the probate section, click on probate, and they'll have all sorts of information about conservators and guardians, okay? That's where you want to go. If you live in Riverside, I'd really like you to go to the San Diego site because they have a fabulous self-help book online, and Riverside doesn't have that. So pull the self-help book from the website down at San Diego County because they're the same forms. But I didn't see that when I was looking at it just recently. There was no self-help book, and it's just excellent, okay? You can do these pro bono. You can do these by yourself. But I am here to assist if you need it, okay? So if you've got a kid that's really close and you're ready to get out, we can get that paperwork going. Okay, so 2 types, general and limited. The general is for adults, usually adults that can't take care of themselves. And we're really looking at elderly people. Our younger people that have been in serious accidents, have had accidents happen to them, as opposed to a limited partnership. And this is what I'm usually dealing with the EFMP population, is these are severe and chronic disability due to a mental or physical impairment that started before the age of 18. And almost always these are regional center clients, okay? Limited partnerships are designed to promote as much self-sufficiency as possible. We're going to talk about the rights and what we're doing when the judge awards the conservatorship. Okay, to make it more complicated, you have the general and the limited, and then under both of those, you can either be a conservator of the person, a conservator of the state, or both. Again, typically for our children that have developmental disabilities, that have regional center services, we get a limited conservatorship of the person. They usually don't have, most of my clients' adult children, don't have a lot of assets. If they do, then we're going to look at being a conservator of the estates. Most of the children are only getting SSI. If they do have more money, then we're going to have to look and get a conservator of both the estate and the person. Okay? So again, looking at this limited conservatorship, we've got 7 rights that have to be put in that petition to the court that you're requesting. These are the 7 rights that you're going to take away from your child. And so the judge is going to go through each one of these 7 to see if it's possible that your child retain any of these rights. In a filing I just did, we petitioned for all 7. Regional Center came back and only wanted 5, but the judge agreed with us and the family was awarded all 7 of the rights. So don't be surprised if that happened. It's up to the judge ultimately, not to Regional Center. Okay? So what are they? The right to determine their residence. Where are you going to live? That's a major right. The access to their confidential records. The right to control their marriage. Right to control, to sign on a contract. Some children may have enough legal competency to sign a contract. Others may not. Consent for medical treatment. To control of social and sexual contacts. That's the one that the judges try to award to the adults as much as possible. Don't want to take that way unless they absolutely have to. And then to make educational decisions. So there's our IEP rights when they turn 18. If they can't make those decisions on their own and you're going to get a limited conservatorship, you definitely would petition for that right also. Those are the 7 rights, and you have to specify all 7 of them, or whichever of them you want. Powers that are never granted are sterilization, involuntary commitment, electroconvulsive shock therapy, and psychotherapy. If a child doesn't want to go to psychotherapy, they're not going to benefit from it, so you can't force them to do that. You're never going to be granted that right. Okay, so how is it established? Lots of paperwork. I think there's 8 to 10 forms that you fill out. They're all legal forms. Again, if you go to the Superior Court website, you can pull up the forms and see them. They're really confusing, but they're very simple, really, once you've done it a couple times, so please don't hesitate to contact me. All right, so you're going to have a petition. One of the pieces of paper is you're going to petition to the court for the right to be a conservator, and you're going to file that. Copies of that petition have to be served on your child, no matter what their competency level is. You have someone over 18, you don't need to get a process server. You get a friend, somebody next door that's going to hand it to your child, hand it to the siblings, hand it to maternal and paternal grandparents. Those are all the people that have to be served to be notified that this is what you're doing. And if any of them object, they can go to court and voice an objection. Sometimes that happens with grandparents. A court investigator is appointed, comes to your house, interviews your child, looks at your child, looks at the surroundings to determine what they're going to recommend to the judge. Regional Center will also submit a report. Then the hearing takes place and the conservatee attends. Really important, the judge wants to put eyes on the child in both of the conservatorships that we did, the child appeared at both of them. Really important for the judge to see them. They can not go if they're out of state, so they're in some kind of medical facility or someplace else where they're out of state, so they're medically unable. Or if they're really unwilling, but they agree with the petition, they also don't have to show up. And the court investigator would know that. So the individual's rights. They have the right to notice, so you have to serve them with that piece of paper. If they have the wherewithal, have it read to them. They can oppose it if they want. So if your child's higher functioning, they can go, I don't want to give these rights away. My parents want to take all 7. I want to keep these. They have the right to do that. They have a right to be represented by an attorney, which they will assign. They have a right to be at the hearing. They have a right to a jury trial, which is usually very rare. And they can have someone, a friend, come with them to speak for them at that hearing. So what are your responsibilities? Okay, of a limited conservatorship again. You're going to assess the needs and how to meet them of your child. You're responsible at that point. You are the responsible party. The judge has awarded you those rights. You're going to secure all those appropriate services to maximize, again, self-reliance and independence, and make sure that health care, they have the proper health care. If you're awarded those rights, that's what you're responsible for. So here's, remember at the beginning, also I want to make sure you understand whether you really need a conservative for your child or not. I thought I would get one for my daughter. I thought she was pretty clear case. She can't hold a job. She gets SSI. But you know what? She really is too high functioning. I couldn't get it. I mean, I didn't even try. I knew I wasn't going to be able to get a conservatorship for her. I recently had a father come in. I'm laughing because this happens all the time. It wasn't just him. And go, my daughter doesn't make good decisions, and she's got ADD. I want a conservatorship. Well, we have the right to make bad decisions. You know, our kids have that right. The judge isn't going to take that away. Okay. So, but there are other ways to get these rights and to deal with your child rather than going all the way to a conservatorship. And that's what we always want to look at first. So again, you're going to look at your child and their unique needs. Can they cooperate to meet their basic needs? To what extent can they do that? Do they have the capacity and the willingness to sign a power of attorney, naming someone to help them with their finances or health care decisions? If they only have Social Security or welfare income, you can be appointed the representative payee. Okay, so you're going to be able to have control of the funds and how those are going to go. And if they get married or have a domestic partnership, then those people may be able to handle all those transactions. So you wouldn't need a conservatorship also. Okay, so we take the financial decisions again. You could be a representative payee. If they have substantial assets, you could have a special needs trust. Again, the power of attorney, if they have the legal competency to sign that. The issue there is with a conservatorship, that's going to stay in place until it's terminated by the court or the conservatee dies. With a power of attorney, you can revoke those whenever you want. So if your kid gives you those powers one day, they can come back the next day when they're angry and go, I'm revoking this. That's all it takes. Then you lose those powers. So a power of attorney can always be revoked, so you have to be careful with that one. You can put your assets in joint bank accounts, and you can have other informal arrangements before you go that full step, to the conservatorship. For the medical things, you can get a release of information like I got with my daughter. She had the wherewithal to sign the release so I could continue to make her appointments. I could continue to do the IEPs. She was able to do that. That was no problem. Advanced health care directives, appoint someone else to make those decisions. They may be able to sign off on those. And there again, you may have some informal type of arrangement with your child. Educational rights, again, they may be able to sign those off just informally between you and the school. And again, you want to make sure they have that self-advocacy training piece of it. Almost there. 2 more. Guardianship. I'm not going to ask for a raise of hand, but everybody in this room should have a will. It's free. Do it now. Now, Arnold Schwarzenegger said in one of his movies, do it now, not tomorrow. Go to Joint Legal Assistance Office, figure out how they do it. I know at Camp Pendleton you have to stand in line and get the forms, make an appointment, and come back. Get the will done. It's free, okay? You want to make sure that you have a guardian appointed in that will, all right? The probate guardianships are court proceedings in which the judge, again, is going to give custody of your child. This is under 18 again, and or the power to manage the child's property to someone who's not the parent, okay? The way that, obviously when you're looking at guardianships, you're not around anymore. So you're appointing someone in your will, you're nominating someone. They're going to have to go through that system, and the judge is going to look at them. So if you appoint someone that the judge is not going to agree with, you've got an issue. I highly recommend if you appoint someone as your guardian, you go and tell them. You talk with them. Make sure that they're willing to accept this responsibility. It's a big one. Hopefully it'll never happen. It does occasionally, unfortunately. But you want to make sure they're willing to do this. You appoint them in their will, and that nomination is going to give valuable information to the court to decide who that guardian will be. So your wish is going to be honored by the judge if they can honor that. So the guardianship is very similar to the conservatorship again. They're going to go to court. They're going to fill out all the paperwork, petition, all right? Guardian becomes responsible for the child's physical care, health, education, welfare until they're 18. Then they're adult. So hopefully you've done some other planning for your child at that point, especially if there's special needs, right? If they're going to need assistance when they're adult, special needs trust, whatever you've got into place, your life insurance policies, make sure they're there. Okay, the guardian, this includes providing basic needs, food, clothing, shelter, health care decisions, and educational choices. And you have to make sure that the guardian knows they're not going to be responsible for meeting the child's financial needs. Usually your child is going to have some finances through life insurance policies or through your estate. So transitions. No one said it, I love this picture. No one said it would be easy, but it will be an adventure. It is hard. It was hard. The hardest thing for me, to be honest, was my husband. He was public health service, which is the white naval uniform. No more uniform. I loved it. I just love guys in uniform. That was big. That was a big change for me, to watch him get dressed in a suit every day rather than wear his uniform. You know, big, it's a little thing sometimes, and that may be it for your child too. Your children not seeing your husband dress up every day in their camis, you know. So transition your kids, let them know that this is what's going to be happening. Okay, I know you've got, where is Jan? That next session starts at what, 9:15? So if there's any general questions, otherwise we'll give you a break and let you split.